Welcome to Into the Woods, the podcast that takes you through a variety of legal topics of interest, where we explore both the forest and the trees.
My reaction is if you're over the age of 18, you of course should have a will.
If you pass away in New York State without a will, that's passing intestacy. And in that case, New York State essentially creates a will for you. And most of the time, that's not the way you would want your assets to pass.
It really boils down to making sure that your assets pass exactly the way you want and make sure your loved ones benefit in the way that you intended.
My name is Dave Shaffer. I'm the chair of the Family Wealth and Estate Planning Group here at Woods Oviatt Gilman. Today's topic is, do I really need a will? Many of us consider this question and perhaps discuss it with loved ones and trusted advisors. Trust and Estates attorney Morgan Napierski joins me on today's episode to unpack this question. So I'm joined here today by Morgan Napierski. Hi, Morgan.
Hi, David.
Morgan, why don't you tell us a little bit about yourself and explain what you do?
Sure. So I'm an associate in the Trust and Estates department. I really enjoy working with clients of all ages and, making sure that their estate plans are in place and they do have a will and the other necessary documents that we do here in the Trust and Estates department.
So Morgan, I heard through the grapevine that back in your earlier days at SUNY Geneseo, you were part of the dance team. Is that accurate?
That's accurate.
Now, as a thriving Trust and Estates attorney in the Rochester community, what type of skills do you think are aligned with your dance background on the dance team and now that as a Trust and Estates lawyer?
So there are a few similarities. Definitely teamwork is one of them. Certainly collaboration in terms of choreography and performance and all that, working as a team. There's also an education piece that I think was pretty aligned with being a dancer, and especially because I was a dance instructor at the studio I grew up in, which was in Batavia, and educating, younger kids and, teenagers in high school. And, through that educational piece, I also educate clients on a daily basis, making sure their estate planning aligns with their wishes. So there's the educational piece as well.
For sure. I mean, teaching is a big part of what we do. And it's what we are also trying to accomplish through the podcast, giving our listeners something to sink their teeth into as they think about estate planning. So today's topic is, do I really need a will? And I think in order to unpack whether you really need a will, the first question is, what is a will?
So a will is a legal document that outlines how you want your assets and property to be distributed after you pass away. So basically, who gets what, you appoint certain fiduciaries such as guardians, executors, trustees.
If I'm just an average person thinking, geez, I don't have extraordinary wealth, do I really need a will? Doesn't New York make one for me if I don't have a will? What happens if I pass away in New York State without a will?
If you pass away in New York State without a will, that's passing intestacy. And in that case, New York State essentially creates a will for you. And most of the time, that's not the way you would want your assets to pass. So it is important to have a will that outlines your specific wishes.
Can I go back a minute from when you talked about fiduciaries? You mentioned guardians and trustees and executors. So just in terms of executor, what does that mean? What does that person do?
That person is going to be somebody appointed under your will who gets authority by the court to collect the assets and distribute them according to the terms of the will.
So that should be someone you trust and have confidence in, presumably.
Yes.
Okay. Now, let's say I'm married and I have 2 kids and I just say, geez, you know what? I've accumulated some wealth, but I'm not really sure I've accumulated enough wealth to have a will or to hire an attorney to help me with a will. Maybe I'll just I think you said it was intestacy. I'll let the New York intestacy laws control. What would happen in a scenario where I'm married with 2 kids in terms of the assets that pass through my will? How would those assets pass if I don't have a will?
So if you don't have a will and you pass away with a spouse and children, The spouse would inherit the first 50,000 plus half of the balance, and the children would inherit everything else.
So, if I have, let's say, not necessarily a minor children or minor child or children, let's say I have a 19-year-old and an 18-year-old, and I've been married for 20 plus years. I pass away without a will. You mean to tell me my 19-year-old is going to get, other than the first 50,000, my 19-year-old is going to get half of the estate, even though my spouse is still alive?
That's correct. And that's why the New York State intestacy statute is most of the time not what you would want.
Right. So it's critical to have a will in that context. Now, okay, you've convinced me. I think having a will makes sense. But now, Morgan, can you tell me, do all of my assets pass through the will or only some of them? How does that work?
So not all of your assets pass through your will, and that's the difference between a probate asset versus a non-probate asset. So a probate asset is an asset owned solely by the deceased person that goes through the probate process. And a non-probate asset is an asset that passes directly to a designated beneficiary outside of the probate process. And that would include assets that are jointly owned, retirement accounts that pass by beneficiary designation, life insurance, joint bank accounts, things like that.
So if I have a life insurance policy, let's just say $250,000 for purposes of giving an example. I have a $250,000 life insurance policy, and I forget to fill out the beneficiary designation, but I put a clause in my will that says I want all my life insurance to pass to my brother. When I pass away, what is the life insurance company going to first look at?
The life insurance company is first going to look at that one-page beneficiary designation form. So that would override what would be in the will anyway. So those forms are really important and should be, updated on a regular basis.
In terms of our practice, Morgan, I mean, when we're working with clients to do a will, is there any discussion in terms of beneficiary designations? How does that kind of fit into the overall quote-unquote estate planning picture?
We discuss both. So we discuss, what's going to go in your will, and we also discuss any assets that pass via beneficiary designation as well. So it's a all-encompassing discussion. That's why at the beginning we get all of your financial information so we can make sure that everything is passing exactly how you want. So we review both probate and non-probate assets.
Yeah, that's a critical part of the estate plan. Now I've got a question for you. I've heard another label thrown around, TOD. What is that all about?
So TOD means transfer on death, and that's essentially a beneficiary designation for non-retirement accounts, such as a non-qualified investment account, for example.
Okay, so with a TOD or transfer on death, although it certainly can be a useful tool in terms of helping clients sort of streamline things when they pass away, it's not always the best avenue to take. One example might be if you have a child with special needs. And if you have, let's say you have 3 children, one of whom has special needs, and in your will, you've structured it such that you're giving equal shares to your 3 kids, but the child with special needs, their share is going into a special needs or supplemental needs trust to ensure that there's no disruption with their government benefits. That's great. But if then you go ahead and take your investment account and slap a TOD or a transfer on death designation on it, and you just list your 3 kids' names, that account is going to go to all 3 kids outright, not into a special needs trust for your special needs child. And it's going to kind of defeat the purpose of what you've tried to arrange in your will. So the point, I think, being that Morgan and I are trying to make is make sure that the beneficiary designations, whether it's IRAs, 401k, TOD, and by the way, TOD, transfer on death, is a beneficiary designation. It's just another phrase. Often it's used with non-qualified accounts, non-IRA accounts, but it's the same effect. It overrides for that account what would be in your will. Sometimes, like I said, sometimes that's good, sometimes that's bad. For real estate, for example, New York passed a law earlier this year that allowed you to do essentially a TOD deed for real estate, but they're still working out a lot of the kinks. Anytime a new law is passed, there's always sort of unintended consequences and nuances that they don't always address. So right now that's a little bit in flux. When it comes to real estate, it can be a little trickier. And oftentimes real estate, even if you're married and own it jointly with a spouse, you leave it to your spouse, or it goes automatically to your spouse if both names are on the deed when you pass away. But on the second spouse's death, the real estate has to be dealt with in the will. Up next is our recurring segment we like to call Show and Tell. This is where we address either a pop culture, Broadway show, musical, basically anything in the entertainment sphere where we can kind of apply the topic we're talking about today to a more lighthearted, fun type of context. So I'm not sure if you're a Swiftie, Morgan. My kids have accused me of being a little bit, but today's topic is going to be the song by Taylor Swift, Anti-Hero. And if you've listened to the song or watched the music video, you'll know there's kind of a death component to it, and will and all that. So just so by way of background for those who are not as familiar, basically Taylor Swift has a dream about her own funeral where her, and by the way, this is fictional. She doesn't have sons, but
She is still alive.
she is alive. Thank you very much. We don't want to panic our listeners, those who are really diehard Swifties. So Taylor attends her own funeral, or Taylor does not attend her own funeral. She dreams of her funeral, attended by her sons, Preston and Chad, and daughter-in-law, Kimber. Kimber's married to, I think she's married to Chad. No, she's married to
I think it's Preston, but whatever. Yeah.
Keep me in line here, Morgan. So anyway, the three evil people are at the funeral accusing each other of killing Taylor. Taylor's watching all this from her coffin somehow, some way. And somehow the last will and testament comes up. They're all very eager to learn how much money they're getting from dear old Taylor. And they learn that she's left them 13 cents and she's bequeathed her assets, including her beach house, to her cats, Benjamin, Meredith, and Olivia. The kids freak out. They can't believe mom didn't leave them anything. They bicker, they complain, etc., etc. So tell me a little bit about how this sort of process and learning about the will, is that grounded in reality in terms of what you see in your day-to-day practice as a trust and estates attorney, Morgan?
So it is a little bit far-fetched from reality. There really is no formal reading of the will, Hollywood movies and TV. It's great for viewing, but, it's not really realistically what happens. There is no formal reading of the will where the family gathers and sees who was left out and what each child received or didn't receive. So that really is more of a fictional type of scenario that Hollywood likes to really play up.
It's fun.
It's fun. It keeps things interesting, but is not the reality of how this process goes when somebody passes away.
For sure. And, there are certain, and it's beyond the scope of today's podcast, there's certain things that must be done in terms of the person's will when they pass, and certain people are entitled to a copy of it, but there's not that formal reading of the will. But I thought for the listeners who may not be as interested in Taylor Swift, we would throw them a little bit of extra info in terms of another pop culture scenario where a will and a reading of the will is brought up. So Morgan, you want to expand on that for our listeners?
I'd love to. And this is really targeted towards the millennial listeners.
We have some of those.
If anybody is a Gossip Girl fan, this example is for you. So to just kind of briefly describe, it is a similar situation where obviously Gossip Girl is about, Manhattan's elite families on the Upper East Side and the penthouses. And the way this episode goes is Serena Vanderwoodsen's grandmother has passed away. They are in her Upper East Side penthouse. The wake is going on, and all the family is talking about waiting for the executor to show up so that they can hear the reading of the will. And in walks Lily Vanderwoodsen's ex-husband. He's the executor. He reads the will, and they learn that Grandma Cece has left all the family out except for this imposter, Ivy Dickens. So it's a similar example. It's, everybody's waiting for the reading of the will, which is just not the reality. So it is a played up Hollywood
Well,
scenario.
like we said, it's fun. It's kind of cool. But in terms of just sort of helping our listeners understand how the process works, there is no dramatic type scenario like that. In terms of the overall importance of having a will, I would assume that everyone should have one, right? But if you can just sort of wrap up the one or two key points in terms of if a client says, do I really need a will? What is your reaction?
My reaction is if you're over the age of 18, you of course should have a will for all the reasons we described. And it really boils down to making sure that your assets pass exactly the way you want. And make sure, your loved ones benefit in the way that you intended. It's important to have the distinction between the probate and non-probate assets and a full understanding of the big picture, right? To make sure, again, going back to the most important thing is making sure that everything passes to whom you want and the way that you want.
For sure. Yeah. I mean, as much as we love good old New York State, we don't want them making the will for us,
Exactly.
right? That will wrap up today's episode of Do I Really Need a Will? We thank you for joining us. I guess you could kind of say, in Taylor Swift's words, we're out of the woods. This is Into the Woods.
You are a Swiftie.
Thank you for joining us today. For Morgan Napierski, I'm David Shaffer. We will see you next time.
Please note that this podcast is for informational purposes only and is not intended to be, nor should it be considered, legal advice. Listening to this podcast does not create an attorney-client relationship. The information discussed is specific to the laws of New York State and may not apply to other jurisdictions. For legal advice on your individual situation, please consult with a qualified attorney.